A very good morning and welcome all of you to the daily news analysis for 26th of March 2025 with me Jatin Verma here on this platform PW Only IAS English. So in the today's news analysis we are going to deal with section 79B of Information and Technology Act. Why Twitter is refusing, why X is refusing to comply with Sahyog portal. Sahyog portal has been created to make sure that the requests for the removal of the content, objectionable content by all the agencies, police authorities, CBI, Enforcement Directorate and National Commission for Women, this should be complied with in a time-bound manner. But what is happening is many social media platforms like Twitter, Facebook, etc., they have raised objections that the section 79 or Sahyog portal does not comply with the Supreme Court judgment of Shreya Singhal case 2015. We are going to see this in detail today. Then government and opposition, they call for Collegium system. Now the review of the Collegium system in the light of the frequent occurrence of charges of corruption, misconduct by the judges triggered by the Yashwant Verma case, Justice Yashwant Verma cash stash case at Delhi. So we are going to talk about this also. Then these are the other news articles. Bhim 3.0 has been launched. The new version of the Bhim has been launched so as to ensure that the kids' expenditures through the UPI application can be monitored by the parents. So a categorization, sharing of expenses can be done through Bhim 3.0. We are going to see how UPSC has asked the questions previously on this topic, guys. Now, Supreme Court takes suo motu notice of the Allahabad High Court. Pocso judgment, Pocso Act, Protection of Children from Sexual Offences Act. This act was created with the noble objective of preventing sexual harassment against the children aged below 18 years, non-adults. Okay, but the Allahabad High Court's one of the judges, he said that pulling the string of the pajama of a kid, 11 years old girl, and dragging her into a kind of isolated place does not amount to sexual harassment. When judges are biased or when judges misinterpret the law, then Supreme Court like body has to take suo motu cognizance. So we are going to deal with this also as to what is the Supreme Court going to do with regard to this matter now. Sahyog portal, then Speaker 𝐂𝐿𝐻𝐿 judgment. You must have read in the M. Lakshmikant what is 𝐂𝐿𝐻𝐿 case of 1992. We are going to see that also. Can there be a limit imposed on the power of the Speaker to decide on anti-defection law petitions filed to the Speaker's office? Speakers are taking 2 years, 3 years. Entire term of the Legislative Assembly goes on and the Speaker does not take a call on the defectors. So this is a kind of judicial power, quasi-judicial power of the Supreme Court and Supreme Court of the judiciary, you can say, of the Speaker, and Supreme Court is now going to review this. Some key constitutional questions have arisen. We are going to talk about them also in today's news analysis. So now moving further, government opposition call for Collegium system reform. There is a need for reforming the system. Why? Because the certain phenomena, objectionable phenomena, they have come up in the sense that judges are appointing themselves and they are appointing their brethren judges. The junior judges are appointing senior judges and the senior judges are appointing junior judges, and then in their term when the juniors become senior, they are taking care of the kids of the senior judges. Okay, so Supreme Court is taking care of High Court judges in so far as their elevation to the Supreme Court is concerned, and when the High Court judges become Supreme Court judges, they take care of the kids and the children of the Supreme Court judges who have retired. So this kind of a phenomena. Then frequent occurrence of the misconduct by the judges. You talk about Justice Yadav case, you talk about Justice Yashwant Verma case, and in the past also, yesterday I told you that CJIs have not been beyond the scope of criticism. Their conduct has also been they have been also subject of the criticism. Justice Deepak Verma, Justice K.G. Balakrishnan, starting from 2010 onwards right up till today, we have seen a lot of cases where judges' own conduct, Supreme Court judges' own conduct has been circumspect. So this is what we are going to see today. That is why the Vice President, the Parliament, the leader of House in Rajya Sabha, leader of opposition in Rajya Sabha, they called a committee and then they said that there is a need for the review of the collegium system where judges are appointing themselves. Now let's see how this system evolved. NJAC versus collegium system. Because of the judgments of the Supreme Court, which are called as first judge's case, second judge's case, then finally the third judge's case, and 2015 striking down of NJAC Act is called as fourth judge's case. So these are the cases. In the first judge's case, this judiciary literally succumbed. Judiciary said that the CJI, the Supreme Court said that the consultation with the CJI, as envisaged under Article 124, is a mere token formality. Okay, consultation does not mean concurrence. President is formally required to just consult the Chief Justice of India, but that consultation is not binding on the President. Okay, so 1981 SP Gupta case, as it is called. Then in 1993 second judge's case, they said that no, it means concurrence. Second judge's case, they said that the consultation with the CJI is binding on the President of India. Okay, and finally in the third judge's case, they said that the consultation with the CJI means concurrence, but there has to be plurality of judges. That means CJI's own advice should not be considered as binding. Not only CJI, but 4 senior most judges, plural number of judges. Okay, that is CJI plus 4 senior most judges of the Supreme Court have to be consulted. So first judge's case, SP Gupta versus Union of India. Second judge's case and third judge's case. So we are trying to understand how did we arrive at this collegium system where judges are appointing themselves. It all started with the Indira Gandhi era, where alongside committed bureaucracy, committed IAS, IPS officers who are committed to the policy of the government, Indira Gandhi government wanted committed judiciary also, so that judiciary should not strike down the important legislative measures taken by the government, taken by the parliament. And in that process, Indira Gandhi government did what? It did the damage to the system, in the sense that the independence of judiciary was given a go by. She appointed the favorite judges so as to give favorite or positive judgments in favor of the government, Indira Gandhi government. So that is why this kind of a scenario started, and judiciary gave all the powers to itself, to the extent that today judges are literally appointing themselves. There is no control insofar as their misconduct is concerned. In-house inquiries are conducted, and they are kept completely undercover. No need to disclose them to public. You talk about RTI, judges being subjected to RTI. Who took the call? Parliament? No. Judiciary itself said that, the Supreme Court itself said that we are selectively under Right to Information Act. So such is the control of judges when they are literally having the control of or control over every administrative, every parliamentary or every government step. You talk about any legislative measure, any executive step, judiciary has power to review it, and it is reviewing every step, CBI, court monitored inquiries, but there is no control on the judges. As the Vice President, therefore, seizing this opportunity of allegations of corruption against Justice Yashwant Verma of Delhi High Court, the Parliament is literally grabbing up this opportunity to not to let go of this matter without starting a debate on National Judicial Appointments Commission. So that is why, what was NJAC? NJAC Act was passed under, or NJAC was created under 99th Constitutional Amendment Act of 2014. This was struck down by the Supreme Court, and this is colloquially called as fourth judge's case. Since this dealt with the matter of appointment of judges, so it is called as the fourth judge's case. In this, Supreme Court said that it in a way interferes with the matter of appointment of judges, so it was struck down on this reason, barely because of the reason that it interferes with the independence of the judiciary. Independence of the judiciary will be compromised. So this is the problem. Now what did NJAC say? NJAC was a body created to end the 2 decades old Supreme Court Collegium system of appointing judges. So was passed by Lok Sabha and the required number of legislative assemblies also. So a bill constitutional amendment bill passed with the special majority, and resolution was also passed by the 15 state legislative assemblies to approve of it. Since we have integrated judiciary in the country, it affects the states also. So states were also required to pass a resolution, and they did so. The act was duly passed, but Supreme Court struck it down for the reason that it interferes with the independence of judiciary, which is a part of basic structure of Constitution of India as laid down in the Keshwananda Bharati judgment of 1973. So independence of judiciary cannot be compromised. Agreed, sir. But if independence is leading to a scenario where frequent cases of misconduct of judges are coming up, then the system needs a review. Okay, so what did NJAC say? NJAC said that it will consist of 6 people: CJI, 2 senior most Supreme Court judges, then law minister, and 2 eminent persons. So here is the composition. NJAC, National Judicial Appointment Commission, will comprise of CJI, then 2 senior most judges, then members from the executive, Union Minister of Law and Justice, and then 2 eminent persons. Okay, these will be legal luminaries or people from different walks of life. So this was the system where judiciary will not have a complete say. So judiciary's 3 members will be there, 3 members from judiciary and 3 members from the executive will be there. This judiciary can, now veto the matter of the appointment. If any name is controversial, judiciary can stop that name, stop that judge from being elevated to the Supreme Court or the High Court. But it will not have judiciary, the Supreme Court Collegium kind of a system will not have complete say, complete control over the matter of appointment of judges. So this was the beauty thing. But executive is facing large number of cases. In fact, the government is the major litigant, most important litigant, I would say. You talk about the cases like electoral bonds case, you talk about other important cases which are filed against the government, Aadhaar Act, etc., etc. Okay, so if the government will be appointing judges and government's own cases will be heard by those judges, then what can we expect? A fair and transparent judgment, fair and objective judgment. So that is why judiciary said that independence of judiciary is the cardinal principle. So we can't compromise with it. But we have to see that a lot of muck has arisen, a lot of allegations have arisen in the last 10, 15, 20 years since the Collegium system was brought in. Lot of cases have come up where allegations of corruption against the CJIs, Chief Justices of India, they have been brought about. So the system definitely needs a review. But the question is NJAC the solution? Why? Because NJAC gives the major in a kind of equal say to the government in the matter of appointment of judges. Okay, so that is the problem here. Now, what is the system in the UK? In UK, judges do not appoint themselves. There is a Judicial Accountability Commission there, right? So any allegations of the corruption, etc., or misconduct by the judges, they are reviewed by the Judges Accountability Commission in United Kingdoms. So such should be the system in our country also, right? So this is definitely a review is required. Proposed appointment, so we have seen all this. Okay, so what is the membership of NJAC? You should be knowing. A question will definitely be there in this year's UPSC prelims. You are also there, I am also here. Okay, so we will see if the question has come or not. Definitely a question around NJAC will be there. Now these are the 3 judges cases. You can quickly revise after downloading the PDF, after downloading the PPT or PDF from the Telegram channel. Once the DNA is over, we'll be sharing that right away. Okay, so these are 3 cases, and 4th case is called as National Judicial Appointments Commission Act case of 2014, where judiciary struck down this important legislative step. Okay, so these are there. This was the 2012 question. What is the provision to safeguard the autonomy of Supreme Court of India? Number 1, while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. Yes, this is definitely an answer. The Supreme Court judges can be removed by Chief Justice of India only. Is it the safeguard? This is a wrong statement. Okay, the salaries of judges are charged on the Consolidated Fund of India. Yes, this is also correct. All the appointments of the officers and staffs of the Supreme Court, the government only, all the appointments of the officers and the staff of the Supreme Court, the government does only after consulting with the Chief Justice of India. This is also there, right? So, what is the provision it is asking? Here, the most important thing we have to choose. So, this will be the answer to this question, right? So, this is how you have to check out the previous year questions whenever some controversy appears in the newspaper. That acts as a trigger factor for UPSC to ask a question around that topic, guys. Okay, now moving further, Bhim 3.0, you must have seen expenso type of applications. These applications, UPI type of applications given by CRED, etc., they enable you to monitor your expenditure. But in the light of the increasing financial autonomy of the kids, we do not have any tool to monitor what are they spending their money on. Earlier, kids were given pocket money in cash. Now, thanks to the advent of mobile phone revolution and fintech revolution in India, we have UPI type of application. But UPI did not have any tool to track the expenses by the children, by other family members. Okay, so now there is a tool. Now the Bhim 3.0 version, the latest version which has been released or will be released for larger public by April 30, it will enable the family members to monitor each other's expenses. Okay, track shared expenses and assign specific payments. Assigning payment of electricity bill to, let's say, father, or to, let's say, the head of the family. Okay, then tuition fee can be assigned to the kids. So this is how this feature enables better financial planning by giving families a consolidated view of their expenses. So Bhim 3.0, Bhim application was developed by National Payment Corporation of India. So this question was asked by UPSC. Every day I am incorporating the questions with regard to the topics that we are covering. This helps you get an idea here at the newspaper reading itself, analysis stage itself, as to how the question can be framed. So since Bhim 3.0 version has been launched, this can be a trigger factor for UPSC to ask a question around UPI or National Payments Corporation of India. So this is the question. 2017, National Payments Corporation of India helps in promoting financial inclusion in the country. Okay, NPCI has launched RuPay, a card payment scheme. So this is how they are framing the questions, guys. Now coming to another important matter of polity and governance, GS Mains Paper 2. So what is happening here? A judge makes a remark that if a man pulls the string of the pajama of a girl aged 11 years and removes the pajama, that cannot be construed as a matter of sexual harassment. And this is not a trial court judge. This is the judge of Allahabad High Court. Okay, so in March 17 order on a plea by the accused challenging the rape charge made in the trial court, Justice Ram Manohar Narayan Mishra's recent observation that a man allegedly grabbing an 11-year-old girl with breasts, okay, so holding her breasts, breaking the pajama strings and dragging her under a culvert is not enough to charge the man with an attempt to rape. Now Supreme Court has taken suo motu cognizance of this matter. On its own, Supreme Court has taken the cognizance of its matter. So this becomes an opportunity for us to review salient sections or definitions of Protection of Children from Sexual Offences Act 2012. This act was passed with the noble objective that even as the adult girls or boys, they can decide about themselves, about their sexual autonomy, as to what constitutes a bad touch or a good touch. Okay, I can decide for myself. A girl aged 18 years or above can decide for herself whether she wants to have sexual intercourse or relation with anybody else. But what about the kids? They are highly vulnerable. As per National Commission of National Crime Records Bureau, the incidents of crime against children, sexual violence, sexual assault or sexual kind of intimidation against children, they are on the rise indoors within the house. Okay, so that is why the naughty after 40 phenomena. That is why Pocso Act was passed with the intention to empower children and their guardians to file a criminal plea against somebody, tuition teacher, bus conductor. These kind of controversies have happened in the schools also. Okay, so if any such kind of a thing happens, the parliament, the government can step in, the police authorities can step in and can arrest that person. This will have Pocso Act was envisaged to have a deterrent effect on the ulterior minds, on the minds with ulterior motives. But the way these type of judgments have come, okay, these have sparked controversy always. Madhya Pradesh, Haryana, and various Rajasthan, where the instances of child marriage are high, okay, these states have empowered, these states have further amended their Pocso Acts. Madhya Pradesh it is, they have amended their Pocso Act to say that if anybody conducts a kind of sexual harassment or sexual violence against a child aged 0 to 12, then he would be subject to death penalty. So the punishment was further increased against anyone if he or she, sexually commits any act of sexual violence or sexual intimidation, etc., against the child aged 0 to 12 years who are more vulnerable. So they will be subjected to, they will be awarded death penalty. Whereas 12 to 18 years, Pocso Act says that, okay, they would be subjected to trial and then 7 years imprisonment, like that provisions are there. Okay. Now, Pocso Act is gender neutral. That means boys and girls are, the children are equally protected. Okay, boys and girls both. It is not only for the girls. This is what you should know. And the second aspect of gender neutrality is that if a man is trying to have some sexual activity with a boy, that is also covered. Okay, if an adult or if a minor is trying to intimidate, if a minor boy is trying to intimidate or trying to affect a minor girl, that is also covered. Okay, so it covers the adults as well as the minors in a gender neutral manner. If a girl is teasing a girl, that is also covered. If a boy is teasing a boy, that is also covered. So this is the beauty of the act, that it is gender neutral. So these are the definitions, etc. Sexual assault on a child definition. The definition is very comprehensive here. See this. Under the Pocso Act, sexual assault on a child includes any act with sexual intent involving physical contact, including touching private parts or making the child touch another person's private parts, even without penetration. So sexual penetration is not important. Okay, is not the necessary condition for the act, for the provisions of the act to be triggered. And it also covers the guardians of law. For example, if a child in the guardianship of a police officer, he has come to seek protection. If that police officer, be it a constable, SHO or anyone, further assaults the child, then that officer, guardian of the law, will be given an even harsher punishment. Okay, so guardians of the law, the people who are who the child trusts, like the parents, tuition teacher, okay, bus conductor. So the guardians are given aggravated punishment because they are breaching the trust of the child, the trust of the adolescent over there. So that is why. Now let's have a look at the other thing. Sexual intent. The key element in defining sexual assault is the presence of sexual intent on the part of the perpetrator of the crime against child. So judge says that the Allahabad High Court judge in this controversy might have believed that removing the pajama of a girl aged 11 years does not tantamount to sexual intent on the part of the perpetrator. He was maybe not having any sexual intent behind it. Pulling the string of the pajama, holding the child with the breasts when he was witnessed by some passers-by. And that is what led to revelation of this crime. Okay, gender neutral, as I said, it is a gender neutral law and holds perpetrators regardless of their gender accountable for sexual offences against minors. So gender is not important. For example, if a sister-in-law in family mets out a kind of sexual assault against a girl, because of lesbian nature of the adult. Okay, that is also covered. So you have to understand this aspect. And gender neutral also means that even if a boy is assaulted by the bus conductor, that is also covered. So it is not only pro girls but also pro boys who are non-adults. Okay, so this also has become an important tool to prevent the or to prohibit the phenomena of rapes within the rubric of child marriages. So this is just a brief on the Protection of Children from Sexual Offences Act. I hope you got the last point. If a child bride and a child groom enter into a marriage, does the child groom, the dulha, the husband, gets the right to rape her without her sexual consent? No. If the child groom enforces himself upon the girl, child bride, to have sexual intercourse without her consent, that child bride would also be prosecuted. Section 375, exception 2. Section 375 deals with the rape. Okay, this was an exception that child brides and child grooms were protected, but not any longer. Supreme Court struck down this exception. Okay, so now शादी के बंधन में बंधे दो बच्चे भी covered है इसमें. Okay, if the child husband says that if a husband below the age of 18 years enforces her, or in a way he is asking for sexual activity without the consent of the child girl, then he would also be prosecuted under Pocso Act. So this is the beauty of the act. Now coming to the Twitter, Ministry of Home Affairs, let me give you the context quickly. Ministry of Home Affairs has created a portal named as Sahyog portal, which in English means cooperation portal. It seeks the cooperation of all the social media intermediaries insofar as deleting the objectionable content proliferating on the internet is concerned. You talk about fake news, you talk about child pornography, okay, you talk about any such hatred, communal violence related content is there, it needs to be deleted in a swift manner. So Sahyog portal has been created to enable, imagine that this is Sahyog portal. Okay, as of now the request can be placed only by the MeitY, Ministry of Electronics and Information and Technology, or PIB fact check unit. Okay, so these bodies were created. But what if Assam police or Manipur police immediately wants the deletion of the video in which women are being walked naked? Okay, so Manipur police raises a request to the Twitter, to the X or Facebook or YouTube to delete that video. So does it need to be routed through MeitY? It will take a lot of time. Request will be sent to MeitY. MeitY will then send it to Twitter. That will take a lot of time, right? So that is why what is now required is that any police authority, Punjab Police, Ministry of Home Affairs, anybody, Ministry of Electronics and Information, they all have an integrated portal, Sahyog portal, where they can place request asking Twitter, Facebook, YouTube to delete the content immediately. Okay, but this is not created under Section 69A of Information and Technology Act. No, this is not created under this. This is created under Section 79 B, 79(3) Clause B of Information and Technology Act. Act is the same, but this is created under Section 79, which is not subjected to the Supreme Court's safeguards for freedom of speech and expression. Okay, freedom of speech and expression is not covered under Section 79B. So what does this mean? Section 69A of Information and Technology Act says that the orders should conform to the orders of the government should broadly accept the freedom of speech and expression. Okay, but Section 79B Clause 3 says that if the social media intermediary does not delete the information, then it will lose the safe harbor clause. It will lose the protection under safe harbor clause. Safe harbor clause says that if the X or Facebook or YouTube does not own the information. Information was uploaded by a person named, let's say Ram, sitting in Haryana. If the information is deleted by Twitter, as per section 79, social media intermediary Twitter will be protected under safe harbor. Why? Because it acted swiftly on the request for deletion. Since Ram uploaded the information on Twitter, Twitter is not the owner of the information, and Twitter, on the request of the police, immediately deleted the video or objectionable content. Then Twitter is protected under safe harbor clause. Agreed? But what is happening now, the Sahyog portal that has been created, it says that the Sahyog has to be given by Twitter if Twitter does not cooperate in terms of deletion of the content in a time bound manner. Then Twitter will stand to lose the safe harbor protection. That means it will be assumed that Twitter deliberately wanted that information to proliferate, that video to continue on the portal, so that Twitter can get more views, more public engagement, Facebook, YouTube. Okay, that is why the objectionable content is also sometimes allowed. Ranveer Allahabadia kind of a video. Okay, so that is why social media safe harbor clause. The Twitter says that X or Twitter is not required to comply with section 79 because it does not have the protection to freedom of speech as wanted by the Supreme Court, as directed by the Supreme Court in Shreya Singhal case. In the Shreya Singhal case of 2015, Supreme Court said that section 69A is subjected to the safeguards. Police can use section 69A to ask for the deletion request, to ask for the deletion of the content, subject to certain principles which seek to safeguard freedom of speech and expression. Okay, now those principles are not being adhered to under section 79. And that is why, to bypass the Shreya Singhal judgment, Supreme Court has created Sahyog portal under section 79. The X says that, therefore Twitter says that, therefore they are not going to comply with section 79 because it is not in sync with the Supreme Court judgment of 2015 Shreya Singhal case. Right now, cannot be compelled to join the Sahyog portal. Supreme Court, the Delhi High Court has been informed by the Twitter. So an online platform developed to automate the issuance. What is Sahyog portal? It is an online platform developed to automate the issuance of notices to intermediaries for content removal under the Information and Technology Act. Then other details, it is developed by Ministry of Home Affairs, important for prelims. Aim is to enable swift and coordinated action against unlawful digital content. Create a clean and secure cyberspace for Indian citizens. Functions brings together all the authorized government agencies right up to the police station level. Okay, in turn to act and intermediaries on one digital platform. So a request will be placed and all the digital media platforms on which the content is uploaded, they will be able to see the objectionable content that they are required to delete in a time bound manner, thereby eliminating the need to send the request to every single portal individually by the government agencies, by the police authorities. So this is the beauty of the Sahyog portal, but the problem is Sahyog portal has been created under such a section which is not subjected to the safeguards that are declared to be important by the Supreme Court in Shreya Singhal case. Alright, now moving further, this is the important paragraph I have highlighted. The PDF will be shared on the Telegram channel and you can download it from there. Now, these things are there. Section 69, website blocking, specifically allows the central government to allow the blocking of the public access to online information, etc. Now, everything that I have explained is covered here. Just give a reading quickly after downloading the PDF. Supreme Court considers the question of timeline for Speaker to decide on disqualification petitions. So what is happening is, in Telangana, the Congress MLAs or MLAs of one or the other political party, they switched sides. Same happened in Maharashtra also. Disqualification of MLAs or MPs is to be decided in a time bound manner, so as to prevent the phenomena of Ayaram Gayaram. MPs or MLAs will keep on changing sides if they do not have the fear of anti-defection law. If the speaker takes too long a time to decide on the disqualification plea filed by their political parties. So anti-defection law's mandate is that it should prevent the instances of unnecessary switching of sides by MPs and MLAs. But if the speaker takes more than 3 months, 6 months, 1 year, 1.5 years, 2 years to decide on the disqualification, MPs and MLAs will not have any deterrent value of anti-defection law. The problem is the way anti-defection law was enacted in 1985, okay, it has not put any kind of time limit on the speaker. There is no time limit on the speaker to decide anti-defection law, to decide the defection petition. Okay, for example, party A filed a petition against 7 MLAs. That 7 MLAs have defected. Okay, the petition was filed with the speaker's office. Speaker is the authority which exercises quasi-judicial power, but speaker is not required to act immediately. Party A, 7 MLAs, they changed sides from party A to party B, enabling the situation that party B was able to form the government. But party A's concern is that these MLAs originally contested the election on the ticket of party A, be it Congress or BJP. Now party B, with the support of these 7 MLAs, it was able to form the government. And the speaker is now not acting against these 7 MLAs. He is not acting immediately. So what is going to happen here? The government is going to continue. 7 MLAs will be made ministers as a reward for their defection. That is why Supreme Court is asking a key question now. Court's question is that when the law and the rules are silent on the time frame, 52nd Amendment Act is the law here, which enacted 1985. Okay, this law enacted anti-defection law. Rajiv Gandhi era was the time period when anti-defection law was brought about for the first time. So now 52nd Amendment Act 1985 says that anti-defection law was created, whereby speaker has been given the power to decide on the petition, to decide whether a case is a case of anti-defection or not. But if the speaker is not deciding in a time-bound manner, can the Supreme Court, unlimited discretion is there, can the courts ensure timely decisions in line with the anti-defection law? If the law is silent, rules are also not saying anything, rules of anti-defection law are also silent, can the Supreme Court fill in the gap? Can the Supreme Court fix a time limit? This is the question. Okay, so an important case with regard to this matter is 𝐂𝐿𝐻𝐿 case of 1992, in which the Supreme Court was approached by the member 𝐂𝐿𝐻𝐿. He said that speaker cannot be given the quasi-judicial power. Since this is a power of judiciary, quasi-judicial power cannot be vested in the speaker, since speaker is the man of the speaker is a political person. He belongs to the political party, ruling political party. Can speaker be given such a judicial power or not? Supreme Court said that yes, speaker has got this judicial power and it is not a violation of doctrine of separation of powers. If the speaker is vested with, if the speaker is given the power to decide whether an MLA has defected or not, there is nothing wrong with this power given to the speaker. But one of the judges who dissented from this majority judgment under 𝐂𝐿𝐻𝐿 case, he had a point that speaker is a political personality. He is not required to resign from the political party. So that is why the speaker should not be given this kind of a power. But now the question is arising that can the Supreme Court fix a time limit that yes, 3 months is the maximum time limit within which the speaker has to decide that yes, this is a case of anti-defection law, or no, this is not the case. If the time taken by the speaker is more than 3 months, then the High Court or the Supreme Court, that is the higher judiciary, will be deciding this matter. Okay, so these things are This is the matter before the Supreme Court now. So court's custodial role. Supreme Court is saying that Supreme Court is the custodian of the Constitution. Okay, if anything wrong is happening, the Supreme Court has the power to, as the constitutional court, Supreme Court has the power to review that law and fill in the gap. Okay, the court questioned its own powerlessness to direct a constitutional authority, that is Speaker, to fulfill their constitutional role. So I ask you a simple question: which is the article which talks about the appointment of the Speaker? Which is the article? And what was the number of the amendment? What was the amendment that was brought about to anti-defection law? 1985 was the first amendment, okay, related to amendment that talked about Speaker and anti-defection law. But I'm asking you another question: what was the second constitutional amendment act that dealt with anti-defection law? So two questions, very simple: the article that deals with the Speaker's office and the constitutional amendment law act dealing with it. Now the petitioner who has approached the Supreme Court, he is saying that in UK, Speaker retires from the active politics after holding the position. But India is one of the such cases where Speaker can continue to be a party man. He is not required to resign from his party position even after getting elected as the Speaker. Since Speaker belongs to the ruling political party, so his prerogative will be to favor the ruling political party and its MLAs or MPs, as the case may be. So why would Speaker act against those MPs or MLAs who have defected, but yet they belong to its own political party, to the Speaker's political party? So in UK, Speaker is made to resign immediately he is appointed as the Speaker, and he cannot go back into the active politics once he is elected as the Speaker. But in India, this is not the case. So that is why this question is arising now. Let's have a look at the 2022 UPSC question. With reference to anti-defection law in India, consider the following statements. The law specifies that a nominated legislator, nominated MP or MLA cannot join any party within 6 months. Please answer this question. Very interesting question it is. So can a Speaker, can a MP or MLA who is nominated, can he join the political party within 6 months, or can he not join the political party within 6 months? He can join after 6 months. This requires a bit of clarity here. The law does not provide any time frame within which the presiding officer has to decide a defection case. So second point is correct, but first point I leave it to you. You have to check your resource for polity and answer this question. Now, how is an in-house inquiry conducted? We are talking about the matter of judicial accountability. In-house inquiry, whenever the allegations of corruption are raised against a judge, so Chief Justice of India constitutes an in-house committee, as has been done in the recent case of Justice Yashwant Verma. Okay, this follows the recovery of huge piles of cash. This has happened. Now, in 1999, this criteria of in-house inquiry was adopted for the first time in Indian judiciary, and it was made public only in 2014. Long road to transparency, first of all. You see, 1999, a criteria is made for in-house inquiry. What is the criteria? We are not aware of it till 2014. Okay, so why so much of opaqueness in judiciary? First thing first. Now coming here, the Chief Justice of India determines if a complaint is frivolous or not. If any allegations of misconduct come against a judge, the Chief Justice of India first of all tests the veracity, the authenticity of the claim. If there is prima facie any iota of truth to allegations, or is it just to tarnish or blemish the record of an otherwise good judge? Okay, if there is an iota of truth, then only the committee will be formed. Okay, if an inquiry is needed, the judge's response and the concerned High Court Chief Justice comments are recorded. Okay, if an inquiry is required the response of the judge. In this case, for example, Yashwant Verma's the version was required. He was given a fair opportunity as to why there was so much of cash kept at your residence. Then Delhi High Court Chief Justice, concerned High Court Chief Justice was also given a chance. His comments were required. That is how the video has come to light. Okay, so this is this is the process being followed by the Supreme Court for conducting the in-house inquiry in Yashwant Verma case as well. Okay, now the CJI forms a 3-member committee. After the truth is found, after there are prima facie allegations, then 2 chief justices from the other high courts. In the Yashwant Verma's case, Punjab and Haryana High Court Chief Justice and Himachal Pradesh High Court Chief Justice, they have been made the members along with the Karnataka High Court judge. So 2 chief justices and 1 judge of the High Court, another High Court. So 3 different judges are going to be there on the inquiry panel. This is how the inquiry is conducted. Courts and other high courts, judges, Supreme Court also, and the judges can be investigated in this manner. Now the committee investigates and recommends whether the misconduct warrants removal or not. So this in-house committee would recommend to the Chief Justice of India, would report back to the Chief Justice of India whether the judge is required to be removed or not. So let me paraphrase it as to whatever we have studied. Allegations of corruption come up against the judge. Okay, allegations. So they go to, even if it is against the High Court judge, allegations are taken up by the Chief Justice of India. Chief Justice of India asks the Chief Justice of the concerned High Court to look into the charges and gives the opportunity to the concerned judge also to present his version. Concerned judge's viewpoint is also taken. आपको क्या कहना है? आपका क्या version है उस पे? After that, if the Chief Justice of High Court says that yes, the allegations have some element of truth, then a 3-member committee is constituted. 3-member committee members are Chief Justice of High Court, Chief Justice of another High Court. Okay, so Chief Justice of Punjab and some other High Court it has to be. Then a judge of another High Court. So in Yashwant Verma's case, Chief Justice of Punjab and Haryana High Court, Chief Justice of Himachal Pradesh, then a judge of the Karnataka High Court have been made the members of the 3-member inquiry committee. This 3-member inquiry committee will give the report, and within the report it will tell CJI that yes, the allegations warrant the removal of the judge. Okay, after that, after this report to CJI, CJI will inform the Parliament, and then Parliament will start taking action for the removal of the judge. What a tardy process. After this removal thing, shouldn't the judge be removed immediately? Then this matter will be put to the vote of the Parliament, and then only the judge would stand to be removed. Otherwise not. After CJI inquiry, again the parliamentary method of removal of the judge as per Judges Inquiry Act will continue. Clear? I have explained this matter in detail. Judges Inquiry Act 1968 will be followed only after the report. Now I frame a question here and I ask you this question. Is the in-house inquiry method given in the Judges Inquiry Act 1968? If imagine this is a preliminary question, prelims question, what is your answer to it? I ask you a simple question. Judges Inquiry Act, which deals with the removal of the judges, does it envisage the in-house inquiry or not? Answer is yes or no. Please answer. Okay. So we have covered this topic in last 2-3 days. That is why I am asking you this question. Regularity is of most importance when it comes to anything in life, more so the UPSC preparation. Okay. Now procedure for High Court Chief Justices. Complaints are investigated by a committee consisting of a Supreme Court judge and 2 Chief Justices from other High Courts. Okay. Procedure for Supreme Court judge. Complaints are investigated by a committee of 3 Supreme Court judges. So if the complaint is against High Court Chief Justice, complaints will be investigated by a committee of the Supreme Court judge and 2 Chief Justices. So Supreme Court judge will be involved if it is a matter of Chief Justice's inquiry. But if it is the other judges, complaints are investigated by a committee of 3 Supreme Court judges. Done? If it is the Supreme Court judges, so Supreme Court judges will be there in the matter of removal of the Supreme Court judges or inquiry against Supreme Court judges. So current case example, we have seen this already. Transparency in the in-house inquiry. Current confidentiality of the in-house inquiries should be changed. This is the first time that Supreme Court has released the information insofar as the in-house inquiry or allegations of corruption against any judge are concerned. Never in the history The charges have been made known to the public. This is the first time. So this needs to be officially changed. Even though the present CJI has taken the call on whether to reveal the video in the public domain or not. But what about the subsequent Chief Justices? Right, so this is the problem here. Key findings of the inquiry should be disclosed to increase transparency and public confidence. But the name of the judge is protected so as to enable him to do his duties in a manner that public trusts him. But public trust also requires the credibility of the judge. And does it mean that public will not even be told about the reasons, the findings of the inquiry? Why would inquiry report be kept under the drawer of the Supreme Court CJI? We as a public want to know whether our judges are corrupt or not. What were the allegations against the judge? Right? So this is the requirement here. Accountability and punishment. The lack of criminal punishment for judges found guilty of misconduct. In this case, brazenness has reached its height. Cash is found right at the residence, and this is a case of criminal punishment. Why are you embroiling it or delaying it by constituting an inquiry and then following the formal procedure? Formal procedure should be followed in deserving cases only. This is a case where cash has been kept, cash has been found, and police needs to do its job, arresting the judge, confiscating the property. Nothing has been done in this case because judges are gods unto themselves. Guilty judges should be held accountable then and there itself. If the same thing would have happened to any IAS officer or a mantri, the fate would have been different, entirely different. So that is the power that judges enjoy in our country. Okay, autonomous investigation body. This is the UK point that I was highlighting. Establish an autonomous and permanent body similar to UK's Judicial Conduct Investigations Office. So UK's Judicial Conduct Investigation Office. So this is to be constituted in India also under the CJI. Judicial Conduct Investigation Office has to be there as a permanent body so as to have a fear of law in the minds of the protectors of law called judges. Right? We all have fear of law except the protectors of law. जब बाढ़ ही खेत को खाएगा तो दिक्कत हो जाएगी. So this is the problem, right? Procedure for in-house inquiry. The press note referenced by the Supreme Court said this is another way in the which was refined further in the 2015 case. Okay, Registrar General High Court of Madhya Pradesh case. The in-house inquiry procedure has two stages. Stage 1, the High Court Chief Justice prima facie assessment of the allegations, truthfulness, veracity. Second, if the High Court Chief Justice recommends a deeper probe, the CJI forms a 3-member committee. Okay, so the details come out through the cases only. First, 1999, the in-house inquiry system was formed. 2014, it was revealed in the public domain. 2015, further judgment of the Supreme Court led to better clarity on the in-house inquiry process or procedure. So, these are the important news articles of the day. This is a very simple article. You can just read it. What is India's approach to the citizens on death row abroad? So we come across a lot of cases or news articles these days wherein Indians are prosecuted and they are hanged till death, or literally they are shot at point blank in the countries, in the Arabic countries. Okay, Saudi Arabia, UAE. So this time it is a case of Shehzadi Khan, okay, an Indian national sentenced to death in UAE for alleged murder of a baby, infant. So this is how the law operates in Arabic countries. What is the India's approach to protecting its own people on the foreign land? Okay, so this is the article here. You can read it yourself. Coming to the other issue, there was one more issue with regard to India emerging as the topmost producer of the milk. Okay, so I just want to tell you to read extensively, carefully about Rashtriya Gokul Mission. So that was a very small news article. We did not incorporate it, but we'll make sure that it is incorporated for the tomorrow's news analysis in the tomorrow's PPT. Rashtriya Gokul Mission was covered a few days back also. Okay, so whenever some feat is achieved by India as a country in terms of number one milk producer, etc., you have to read about milk revolution, Operation Flood, etc., insofar as milk production is concerned. Okay, and the factors that led to India emerging as the topmost milk producer. Rashtriya Gokul Mission was started in 2014. It talks about in artificial insemination of the good quality of breeds. So those are the elements of it you have to cover. This was all in today's news analysis, and I can only request you all to answer all the questions. These are all authentic UPSC previous year questions that have been asked in today's news analysis. This was all in today's news analysis. Thank you guys. See you again tomorrow at around 8 a.m. 8:85:87. But it will start around the same time every day, and PDF is shared on the Telegram channel. The link of the Telegram channel is given in the description box of this video. This was all. Thank you. Bye-bye. Thank you guys.